This is a part-heard appeal in the matter of VietJet Aviation Joint Stock Company versus FW Aviation Holdings Run Limited.
Good morning.
Good morning, my lady, my lords. Before the court rose yesterday, my lady asked me whether we needed to sit early, and I said confidently, perhaps a little too confidently, that we were on track. We've looked at where we are overnight. There is quite a lot to get through. I've canvassed this briefly with my learned friends. It may be that at some point we may need to ask the court's indulgence to sit either a little late or a little early. What I was going to propose is that we, so to speak, keep it under review. We see where we get to. My learned friend, Mr Thompson, will be on his feet next. And just to put a marker down, let's see how we go. I hope that's
And it will be wonderfully succinct to say. We'll see.
I'm grateful.
And I'm not sure that sitting later tomorrow is an option.
I'm grateful.
No, it isn't tomorrow.
Right.
And only for a short time this evening.
Yes.
So, if anything, we would have to sit early tomorrow, I think.
I'm grateful. Well, as I say, let's see where we get to. I just thought I should mention that for the convenience of the court.
I think you had some homework as well.
I did. And I hope I've done it, or at least attempted it. What I was going to do with the court's permission is to say a few words, and literally a few words, about the respondent's notice point, which I was going to come to, and then to come to the homework. I think there were 4 questions which are outstanding from the court. So if I can do it in that order, please. And obviously, given the time, I'll try to take this as briefly as I properly can. The respondent's notice for the court's reference is at Core Bundle 8 at page 172. The relevant section is section 6 at 174. And we object to the first 2 points. We also say point 3 is wrong, but we don't object to it being raised. And what I propose to do now briefly is to set out the nature of our objection to the first 2 points, so the court has it, although the court will have seen some or all of this in writing in any event.
You say it's new.
Well, yes, we say really 2 things. First of all, we say points 1 and 2 are not a proper respondent's notice points, but they're points for a cross appeal, for which my learned friend doesn't have permission.
Yep.
And secondly, relatedly, we say they're points which this court has bundled. And the reason I do that is because the 3 bits I want to show the court are all in there. It's at tab 22. The relevant rule is set out at paragraph 17, which is at page 556. And essentially, that provides, and this court will be more than familiar, that a respondent's notice without permission to appeal must be asking the court to uphold the decision of the lower court for reasons different from or additional to those given by the lower court. And the court sees in the next paragraph, 18, an excerpt from the practice direction, which is also set out. And subparagraphs 2 and 3 distinguish between 2 situations. On the one hand, a respondent who seeks a variation of the order below must file an appeal notice and get permission, but a respondent who seeks to contend that the order should be upheld for reasons other than given by the court below must file a respondent's notice but doesn't need permission. And the reason I was taking the court to brace yourself is if the court scrolls through to paragraph 31A, which has been highlighted at 561, the court will see that that is simply set out in that paragraph 31A. It's said to be a clear distinction. Now, I probably could spend all morning on this because we could have an interesting but perhaps somewhat arid discussion about cases which might be marginal between the 2. But this isn't one of those cases. We respectfully submit that in this case, FWA, what they're seeking to do, clearly falls within the first category because they're seeking to challenge or vary the order. And the reason I say that is because the relevant decision or order in this case is set out at Core Bundle, tab 4, page 60. And it's the second of the orders under appeal, which was made after the consequentials hearing. And paragraph 1, which the court sees, declares that the defendant's right to lease each of the aircraft was terminated, pursuant to the termination notices sent to the defendant in accordance with 19(1)(b), and then there were various dates set out. And that gave effect, that declaration gave effect to the judge's decision, which was that the leasing was terminated pursuant to the termination notices sent in accordance with clause 9(1)(b). And that's the sole basis on which the judge considered the question of determination. He didn't consider, let alone determine any alternative case that the leasing was terminated by some other means. Now, what Malone & Friend now seeks to do is not to uphold that decision of the judge for other reasons. They've not put forward reasons why the termination notices sent in October 2021 had the effect of terminating the leasing. Their points 1 and 2 seek to replace that with a different decision, a finding that the leasing was terminated by a different means, i.e. the sale of the aircraft.
But what about paragraph 2 of the order? Defendant does not have the benefit of any rights or interests in the aircraft. Are they not seeking to uphold that decision? That order?
Well,
on these respondents' notice grounds?
I didn't understand that to be the case. I understood that the focus was on paragraph 1.
Well, I know that the respondents' notice points are expressed to be
yes.
if ground 1 succeeds.
Yes.
And that is the termination by reference to clause 19.
Yes.
But
it's a
this is part of the order.
Yes.
And this is, if they are right on their respondents' notice point, it is an alternative ground for upholding this part of the order, isn't it?
Well, I mean, but insofar as what they want to do is to rewrite or reformulate paragraph 1 of the order, that is a different basis, because and this is the point I'm coming to, the damages flow is very different. The amount of, and this is the point I was coming to, the amount of the monies which flow from the termination is very different, because a substantial part of the claim was made under clause 19.3 of the sublease. Now, our liability to pay the amount set out under 19.3 only arises on service of a notice of termination, if at all. So, I
understand that, but I'm not sure that meets the point I'm making, does it?
Well,
it may go to your second point, that
yeah.
it's not a matter that this court can or should or is able to deal with.
Yes.
I'm not sure it meets they need permission to cross appeal.
Well, I don't want to split hairs with my lord, but I would respectfully submit that it does mean that they need permission to cross appeal if they're seeking to undo or vary paragraph 1. If all they're seeking to do is to uphold paragraph 2 on a different ground, with respect, I see where my lord is coming from, if I can use that phrase. But I do respectfully submit that what they can't do is say, well, because we've got paragraph 2 in very wide terms, I can run this point, and at the same time I can overturn paragraph 1, because that really is to at least completely different damages, flow. The other 2 points I was going to make. First of all, there's a pleading point made against us to say that we've accepted that it said that it's common ground that if the leases didn't terminate pursuant to the termination notices, they terminated pursuant to the sale of the aircraft to the trustee owners. The short answer to that is it's not common ground. I won't take the court to the actual pleadings, but can I just give the court the references? When the court looked at the pleadings, which is at core bundle 13 at 289, at subparagraph 4, we explain in terms that what we're pleading is entirely subject to our arguments in this court. So, and there's a further proviso for the transcript at page 303 at paragraph 22(2). So, if we succeed on our ground 1, we submit that the effect will be to overturn the judge's finding that the termination notices were valid, and in those circumstances, it is certainly not admitted by us that the leasing was terminated by reason of the sale to the trustee owners. We'd have to plead that out and argue it. The second point on the can this court deal with it part of the argument is related to the point I just made. I said that it would have very significant implications for the quantum of any claim for the reason I gave. it's also the case that if ground one succeeds, it would be common ground that there wouldn't have been an enforcement event under the loans. And that would beg obvious questions about the validity of FWC's actions qua security trustee. Because as I showed the court yesterday, under clause 16.3 of the loan agreements, the powers of the security trustee were expressed to be exercisable only upon the occurrence of an enforcement event. And we've identified in our supplemental skeleton, which I won't read out, further issues which may arise in relation to the New York mortgages, which would obviously encompass issues of New York law. So, for example, again, just to give the court the reference, given the time constraints, at Core Bundle 22 at page 558, Clause 4 of the NEO security agreement, and for my Lord Justice Popplewell, that's Supplemental Bundle 15 at 1191, under heading remedies of the security trustee upon an enforcement event, the power of sale under 4.1.1b only arises upon the occurrence of an enforcement event. And that agreement is governed by New York law. There's similar issues under the power of attorney. Suffice it to say that once there is no enforcement event, there are very real questions about the powers of FWC, qua security trustee. So that's an additional reason why we say with respect that this court, so to speak, shouldn't go there. And I suppose therefore my answer to my Lord's point is, insofar as a point can be limited to the paragraph 2 of the learned judge's order, perhaps, I wouldn't want to go further than a perhaps, but certainly once it goes beyond that, then we do suffer very real prejudice, and this is a completely different case and leads to very different consequences, both in terms of quantum and in terms of other legal issues.
In other words, if you're right on ground one, then the declaration in paragraph 1 goes.
Yes.
And the declaration in paragraph 2 needs to be remitted. Is that?
Yes.
Because it depends on issues that are yet to be determined.
Yes, exactly. And the working through, if I can use that phrase, of this court's decision on ground one will be a matter for the High Court, but for the court below. Yes. That's all I was proposing to say about that point. I will now try to hand in my homework. There were 4 questions. To take them in this order, the first was a question by my Lord Justice Zacaroli, I'll give the transcript reference if that's helpful, page 83, line 20, about the co-extensive rights provision at clause 3.5 of the lessor security assignment. And I was referring to the limitations placed on the exercise of those rights by the lessor. Now, the question put to me was whether that, i.e., if the exercise of a right would adversely affect the value of the aircraft, whether that restriction only meant that only the security trustee could exercise the right, whether that applied both before as well as after an enforcement event. And insofar as that was a question, I'll come to another formulation of it. Insofar as that was a question, I'll stick with the answer I gave, which is yes, the security trustee can only exercise its rights after an enforcement event, and I dealt with what has been called against me the lacuna point.
Attention please, attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers.
Hope to see you again shortly.
Attention please, attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention please. Attention please. This is the incident control officer. A fire has been detected in your building. Please evacuate the building now by the nearest fire exit and go to the designated assembly area. Do not run. Do not use the lifts. Follow the instructions of fire evacuation officers. Attention, please. lifts. Follow the instructions of
Attention please. Attention please. This is the incident control officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the incident control officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
ways to save lives.
I mean, it doesn't matter that. Yeah? Thank you. Thank you for spotting. Yeah. Yeah, but thank you for spotting. I think I just turned it.
The laptop's not responding.
I'm just carrying on. Yeah.
I'm gonna have to log into everything. It's weird. Let me see if I just. No, it's not.
That's what I mean. Exactly. We are so on the same page. Yeah. And on it. Yeah. Totally. I'm totally with you. Cool.
I'm
Control.
True. We just lost our train.
Yeah. That's what I said to my wife.
Good luck with that.
Yeah, it doesn't work.
And then we'll go back.
Yes, exactly. On the order. The point is that
But that's where he's got a where we got to this far. I don't want to go on.
I've just slacked.
well, I hope so.
Pardon?
We said that, so I think he sees that.
I hope so.
Yeah.
Yeah, I'll do that.
Clark.
Oh wait, no, because it will turn it off for everyone. Yeah, and it's not working.
What's happening?
The laptop's not responding, so I've just messaged tech support. So hopefully.
Is that the
Which one? This,
This is for those screens.
for the
those
dogs.
screens?
Yeah.
We might well be able to. I think we'll work.
It's damaged in the fire.
Are we right in thinking that everybody is ready?
We are.
Good.
My lady, I've just been informed that the screens, like the document screens, may not be working, but I was proposing to carry on because I think if the court's working off paper, and I'm in sort of homework territory, I was halfway through my response to my Lord Justice Zacaroli, and I'd reminded the court of my, so to speak, lacuna point, which we say isn't a lacuna. And I was going to go on to say, if the question which my Lord was putting to me was the other way around, so to speak, whether the lessor can exercise coextensive rights before as well as after an enforcement event, with my respectful submission, the answer to that question would also be yes. There's nothing in the coextensive rights provisions which limits the exercise of those rights such that they can only be exercised by the lessor after an enforcement event. 7.1 doesn't condition the rights of the lessor, only the security trustee, which are the submissions I was making under round 1. That's the first piece of homework. The second piece of homework came from my Lord Justice Popplewell, which was, if I can paraphrase my Lord's question, page 22, line 5, why is there no event of default under the loan agreement? The short answer, my Lords, is that it was common ground at trial that at the time the termination notices were sent, there was no enforcement event for the purposes of the lessor security assignment. We can trace that through the written closings, but as the court will appreciate, an enforcement event was defined as a continuing loan default, or the loan having been accelerated and not paid. We looked at those definitions yesterday. We pleaded, and the reference for this is the defence core bundle 13, page 294, paragraph 13.6a. We pleaded that at the time of the termination notices, there was no continuing loan default. That was not challenged in the reply. There was no plea back to it. As to why there was no default, which may be the burden of my Lord's question, I'm not sure I can really help on that. That is the basis on which the trial has been conducted. Right. That may be a bit of, the dog ate my homework, but that is my answer to my Lord's question, being as helpful and as frank as I can. My Lord had sorry, I think this was a question from my Lord Justice Zacaroli. Had another question. This is 97 to 98 of the transcript, relating to clause 3.5.1c. And again, if I can respectfully paraphrase the question, I think it was really, what on earth does this mean? I'm not asking my Lord to agree with me that was the question. Essentially, it works this way. A deals with consents and waivers. B deals with any right other than a right of the nature referred to in A. So B covers everything not in A. What therefore does C apply to? Because A and B would appear to be the entire universe. C would appear to be an empty set in mathematical terms. I said that I would search overnight as to where we got to in previous notes and things. That hasn't borne any useful fruit, let me put it that way. Essentially, if I don't have a good answer to my Lord as to what C is doing, it may have been included in error, something may have gone wrong with the drafting. I don't think it affects any of the issues actually before the court on the appeal, but I've done what I can to answer my Lord's question.
The dog's eaten that homework as well, unfortunately.
Well, this court has set...
Let me hold you up.
Yeah. Last one, which I think goes back to my Lord Justice Popplewell. The subjective element point of clause 7.1.5, 102 to 104 of the transcript. This was to test my submission, as I understood the question, that clause 7.1 doesn't grant anything which isn't already granted by the assignment. And my Lord's point, as I understood it, was whether these clauses contain more extensive rights than the security trustee would otherwise have simply under the assignment. And I could also perhaps pick up here a query from my Lord at page 71 of the transcript as to whether there was any retained equity of redemption or rights of that nature. Now, clause 3.4, 3.5 and 3.6 are part of the definition of assigned property, which we looked at yesterday, and they serve to define, therefore, which choses in action are assigned by the lessor to the security trustee. And as my Lord says, they're necessarily objective, to use my Lord's language. Now, the assigned property is assigned by way of security, as my Lord Justice Zacaroli put to me yesterday, at page 72, line 9. That comes from the wording of clause 3.1 of the lessor security assignment. We looked at that yesterday. For the transcript, the references are core bundle 19,537, supplemental bundle 12,898. And the security trustee gives the usual covenant to convey it back to the lessor when the secured obligations are discharged. That's in clause 3.2 on the same page. So in that sense, the security trustee doesn't take the assigned property, so to speak, free and clear, but as security and subject to an equity of redemption. Now, we don't say that the effect of the assignment is that the security trustee takes possession, so to speak, of the assigned property. What clause 7 does is deal with what the security trustee can do with the assigned property once it's been assigned. If we're going to use the language of possession, we submit that the way this works is that the security trustee can take possession of the assigned property, i.e. by doing the things listed in clause 7, but only once an enforcement event occurs. Now, coming back to my Lord's question about 7.1.5, this clause refers to all of the antecedent or ancillary steps which might be required, quotes, for or in relation to any of the purposes listed in the preceding clauses. And my Lord suggested that the wording of 7.1.5 seemed to import an ability to form a subjective judgment, which might be contrasted with the objective test about what is or isn't permitted in relation to the realisation of the security. In my submission, the may consider necessary or proper wording is likely there because, as I said yesterday, clause 7.1 has a dual purpose. It not only conditions the powers of the security trustee, but also spells out the breadth of the powers and actions that the security trustee can take following an enforcement event. And we do submit that there is nothing in 7.1.5 or 7.1.4, for that matter, that's inconsistent with our case, that the intention of 7.1 was to make all of the powers of the security trustee subject to the requirement of an enforcement event. That is a more substantive dog, if I can put it that way, than the previous two. I hope I've dealt with the points. Unless the court has any further questions, I was going to hand over to my learned friend, Mr Thompson, for ground 3.
Thank you.
I'm grateful.
Mr Thompson.
My lady, my lords. I'm going to deal with ground 3, and perhaps I can just take your ladyship and lordships back to orient ourselves where we are. If you pick up the core bundle tab 15, page 409, or the supplemental bundle tab 8, page 248, you will see the definition of qualifying lender, which my friend Lord Wilson took you to yesterday. Of course, it is only possible for Fitzwalter Capital trading partners to be able to take assignments of this loan without seeking the borrower's consent if it was a qualifying lender. That is the focus of ground 2 that you heard yesterday, 3 and 4 that you'll hear today. And the reason for that is, as you see in the qualifying lender definition, this is the NEO agreement. 1 and 2 clearly don't apply because they're about Japanese entities or Japanese-based entities. So it's Roman 3 we're in. You saw yesterday the arguments, or you heard yesterday the arguments about whether FWC was a financial institution, which is X. We can pass over Y, and it's Z that we're now looking at. Benefits from a double taxation treaty with Japan so that no withholding tax will be levied in relation to payments of interest, the relevant DTT, being qualified as an entity that can receive such interest free of withholding tax under the relevant DTT, the relevant regulations, not acting through a branch in Japan. Just, if you will, while we're here, could you look at the CEO loan clause 9, which is slightly different. This is tab 15, page 442. Supplemental bundle tab 8, page, 9, 424. It's slightly different. There's the same structure, the definition of qualifying lender. 1 and 2 are therefore irrelevant. 3, however, has this wording, has a special exemption status with regard to the application of withholding tax by virtue of any treaty or other similar provisions and complies with all relevant requirements, etc., so that no withholding tax will be levied in relation to interest or any other types of payment that is or may be payable to such lender, whether directly or not, under or in connection with the operative documents. In fact, it is agreed that the operation of those two clauses in these two different loan agreements turns on the same question. That is to say, or questions, that is to say, can FWC in either case take advantage of the treaty the UK-Japan tax treaty because it's a UK company. And there are two facets to that. The first is, can it take advantage of the treaty as an entity? Is it the sort of entity which is permitted to take advantage of the treaty benefits? And the second, and that's ground 3, which I'll be addressing you on shortly. And the other is, in relation to the interest payable, or at least theoretically payable, on this transaction, the transaction by which they purchased the loan debt, is that something which is available to have taxation relief? Can they get taxation relief for that particular acquisition? And that's ground 4. And my friend Lord Wolfson will be jumping up again to deal with that when I've dealt with ground 3. Ground 3 is the more complicated and convoluted of the two, and some of the ground I'll be covering will assist, I hope, with your understanding of ground 4. So Lord Wilson and I will ensure that there is no overlap there. Can you pick it up then at the judgment, tab 5 of the core bundle, if you still have it there, page 127. It starts at 126, but the substantive bit I want to show you is 127. And the learned judge said, VietJet's case, this is 249 at the top of the page, VietJet's case is that FWC was also not a qualifying lender under any of the loan agreements. There were, of course, 4, 2 NEO, 2 CO, for the further reason that it did not benefit from the DTT for the purposes of the NEO loan agreements or have a special exemption status under the CEO. That's what I've just read to you. And then the judge quotes the treaty. Article 11.1 says, interest arising in a contracting state and beneficially owned by a resident of the other contracting state shall be taxable only in that other contracting state. So to translate it into the facts of our case, interest arising in Japan, but beneficially owned by a resident of the UK, shall be only taxable in the UK. That's what they're trying to achieve, an exemption from being taxed in Japan. 22.1 of the article, the judge continues, says, provides that only a qualified person as defined is entitled to the benefits. But then there's an exception, because if you read 252, the judge says it's common ground, FWC is not a qualified person. So it falls outside 22.2. FWC therefore needs to fall back on 22.5, which provides as follows. This is the clause in italics we're going to be spending a lot of time focusing on. I'm not going to read it out here because we will be looking at it. But at 253, just pick up the judge isolating accurately what is in dispute. In order to satisfy the 22.5 requirement, FWA must show that FWC was carrying on business in the UK, that's 1, that the business carried on by them was not making or managing investments on its own account, that's 2, and that the exclusion does not apply with the business is that of a bank, insurance company or securities lender. There's no issues to the first. They were carrying on a business. And the third's not applicable. So the issue is only the second one, whether FWC was carrying on a business of making or managing investments on its own account. That is the entirety of the point on ground 3 that we need to look at. Can I take you then to the treaty itself, which is at tab 3 of the authorities bundle. This is the Japan-UK double taxation treaty. It was made in 2006. Many, I hesitate to say most or all, but many of these double taxation treaties around the globe are modelled on or based upon models provided by the OECD, and so there's some commentary and guidance on what they mean. But let's look at the document itself. If you pick it up, please, at page 8. I'm sorry, that's just the start page. Firstly, if you look at page 12, you can see in the definition section, after a collection of definitions, it says at Article 3.2, as regards the application of this convention at any time by a contracting state, any term not defined therein, we might say herein, shall, unless the context otherwise requires, have the meaning which it has at that time under the laws of that contracting state for the purposes of the tax to which the convention applies, as meaning under the applicable tax laws of that contracting state prevailing over a meaning given to the term under any other laws of the contracting state. So if it's not defined in this document, you look first to the tax laws of the UK and the particular taxes are income tax, corporation tax and CGT. to try and find the meaning that the term has. The term we're actually focused on, or the terms we're focusing on, just to remind you, is business of making or managing investments. Business is partially defined on the preceding page, but only so as to expressly include professional services and other activities of an independent character, which doesn't take matters any further. Looking at the structure of the treaty in a little bit more detail, if you go through page 18, you can see Article 10, just the first word, deals with dividends. Article 11, page 20, deals with interest. Article 12, page 21, deals with royalties. Article 13, page 22, deals with gains. Article 14 is about salaries, wages and other remuneration. These are the sorts of income that the treaty is concerned with. The article we're concerned with is 11. It's about interest because it's a loan. And so ground 4 of our appeal will be coming back to Article 11 and looking specifically at para 7 of Article 11, which is about the main purpose for which the transaction has been entered into. And it is focused, just to steal some of Lord Wilson's thunder, on the creation or assignment of the debt claim. So it's looking at the transaction in Article 11.7. And that's why I say that bit of the test is focused on the transaction itself. Now we have to go to Article 22, which is where the hard work starts.
Article 13,
yeah,
dealing with gain.
Yes.
Gains from immovable property in one.
Yeah.
And then gains from alienation of shares.
Yeah.
So that applies to capital gains on share dealing.
Yes. Yes. But not to our case, obviously, because here we're just talking about interest under a loan. That's what they purchased.
Of course, but we have in mind when we get to 22.5 that it applies to these various provisions.
Applies to all of them.
That's why they're showing.
Yes.
They're showing us.
Precisely. It applies to all of them. It applies to royalties as well, and so on. And the provision of the treaty, which I'm not going to go into, shows in which instance they should be taxed in the source state and in which they should be taxed in the receiving state. That's the whole point of the treaty, so that the countries, the states can agree how they're going to divide the benefit of the taxation on the taxpayers according to whether they come from the source or the recipient, depending on what sort of money it is, what sort of flow there is of money. So Article 22 starts at page 26 of the bundle, and you can see at paragraph 1, it says, except as provided otherwise in this article, a resident of a contracting state that derives income, profits or gains, as described in paragraph 3 of Article 10, paragraph 1 of 11, or in 12, 13 or 21. So that picks up what my Lord Popplewell's discussing, gains, as well as profit and income, and interest, of course, because that's Article 11. From the other contracting states, so if we're in the UK...
So 21 is a sort of sweep-up of generally anything not dealt with elsewhere.
Anything else.
Is that right?
Yes, I think so. Yeah. Luckily, we're only focused on 11, but I think you're right, my Lord. It's any other income other than income out of trusts and estates of deceased people. But there's no doubt that we're in 11.
Well, we're in 11 for the purposes of our agreement, but if we're interpreting what is meant by 22.5, we have to have in mind, don't we, that it has to have a meaning that works for all these different categories.
I accept that.
That's why I'm focusing on this.
Understood. Yes. No, I accept that. So it shall be entitled to benefits, that is to say the resident, granted for a taxable year or chargeable period by the provisions of those paragraphs or articles only if such a resident is a qualified person as defined in paragraph 2 and satisfies any other specified conditions in the paragraph. Each of the articles has their own distinct collection of conditions that apply to particular source types of income. So 2 or gain. So 2 then says, paragraph 2 of Article 22, a resident of a contracting state is a qualified person only if such resident is either, and then there's a list of people who are qualified persons, and I'm not going to go through it in detail, but you can see individual is the first one, then government entities, certain types of companies that are listed, that's C, and then other persons that other entities that are on stock exchanges. You can see at E, that's basically charities and pension funds, but only if 50% of the pension funds are from the contracting state or one of the other contracting states. 22G, I'm jumping over F intentionally, is trust, and that leaves F, and F deals with private companies, effectively. A person other than an individual, the residents of either contracting state that are qualified persons by reasons of one of the other paragraphs, own, directly or indirectly, shares representing at least half of the voting power of the person. So if it's a company that's resident in the UK or Japan, i.e. incorporated in one of those countries, which is owned at least as to half by Japanese individuals or Japanese government entities, then that qualifies. 22.3, the next paragraph, says that a private company, if 75% of the voting power is held ultimately by 7 or fewer persons, also qualify. So what we have here, and this is common ground, is that FWC isn't any of those. It doesn't fall into F and it doesn't fall into para 3. But it's just worth stopping to think about the people that are qualified here. It's effectively, and who the treaty is there for the benefit of, it's trying to capture residents and exclude non-residents. That's the sort of primary focus. And the reason for that, which is comprehensible and well recognised, is that you don't want to provide, by creating a double taxation treaty between two states, collateral benefits to people who are not resident in either of the two states. And that would include people who establish, through the very simple process, a company in one country or the other, but are still resident in the third country. So that's the limitation, the structural limitation in 22.3. And this underlies the reason why there are so many strictures within the treaty about who can and can't take the benefit of it. It's to make sure that people don't either abuse the treaty or shop around for a country that has an attractive treaty. Now, on our facts, and this is common ground, FWC falls into a company that's outside 2 or 3, paras 2 or 3. Can I just show you, because I don't think you've seen it, the structure chart of Fitzwalter? That's in the supplemental bundle, tab 6. This is in a witness statement of Mr Weinstock, who was the only witness from Fitzwalter Group entirety who gave evidence at trial. And in fact, he's not from either of the companies that we're mainly concerned with. He's employed by Fitzwalter Capital US, and my Lord Wilson will have something to say about that later. But I'm going to come back to this later. But if you pick up 169, you can see the organisation of the group. Bear in mind this is as at October 2023, and it's quite a young group, so there were entities here that didn't exist in 2021. So take it with a pinch of salt, but these bits are still clear and important. On the far right of the table, up from the bottom line, you see Fitzwalter Capital Partners Financial Trading Limited. That is the company we all call FWC. That is the company which we are focused on, although my learned friends think we're not. We accept that's the one to focus on. FWA, the respondent, is at the other side of the table on the far left. FW Aviation Holdings 1 Limited. That's the respondent, a Jersey company. Immediately above, and the owners effectively of both those two companies, one indirectly, one directly, is another Jersey company, Fitzwalter Capital Partners Master Hold Co Limited in light blue. That's a Jersey company that owns both FWC and FWA in their entirety. Then up from there, Fitzwalter Capital Partners 1. That is known certainly by Mr Weinstock, and I'll adopt his definition, as the fund. That's where the money is. And the investors, you can see, come in from the right there. And then there's a limited partner and a general partner in a regular hedge fund structure. And Fitzwalter Capital Limited is now on the second line from the top, just below the top company on the left, Fitzwalter Capital Limited, which is an AIM-listed company that, which is a company that operates as the manager of the fund, the management and advisor. The general partner, as you see, is Fitzwater Capital Partners GP Limited, which is in the slightly darker blue right in the middle of the page.
So which is the manager? Fitzwater Capital Limited?
Yes.
Top left?
Top left. One of, but that's the one that Mr Weinstock says is the manager.
And the general
It
partner
depends
is in the middle or at the top?
I'm sorry, my lady?
And the general partner is...
The one right in the middle,
Right in the
sort
middle.
of middle shade of blue in the
Yeah.
middle of the page, Fitzwater Capital Partners GP, general partner, I imagine. So that's the structure certainly in 2011. For what it's worth, Mr Weinstock was employed by the US company, which is halfway down the table on the far left.
And I thought I picked up somewhere, but I may be wrong, that it's Holdco, the Jersey company, which owns the fund's assets. Is that right or not?
I think that is right, yes. I think that's right. Anyway, we will have to come back to that for various reasons, I suspect, later. But what's important to recognise now is that there are multiple owners through the investors, ultimately, of FWC, because of the investors. And Mr Weinstock says they have pension funds and all other people who invest, as well as the internal people, if you like, who are seeking to make money from the operation of the hedge fund. So the respondent, as the learned judge pointed out, we can put the chart away. I'll go back to the authorities bundle, needs to bring itself within 22.5 of the treaty. And before we descend to the actual sentence that we need to look at, just take the structure of it. Notwithstanding that a resident of a contracting state may not be qualified person, that's obviously what FWC is, that resident shall be entitled to the benefits granted by those various provisions, including Article 11, with respect to an item of income, profit or gain described in those paragraphs or articles derived from the other contracting state, so income from Japan, if, and there are three conditions, the resident is carrying on business in the first contracting state, and then an exception to that, other than the business of making or managing investments for the resident's own account, and then a carve-out to the exception, unless the business is banking, insurance or securities business carried on by a bank, insurance company or securities dealer. And then, and this is the second condition, the income, profits or gains derived from the other contracting state is derived in connection with or is incidental to that business. And then the third condition, the resident satisfied any other specified conditions in those paragraphs or articles for the obtaining of any benefits. Now, the court can put out of its mind the second and third conditions. They aren't in dispute, except that the income which derived from Japan was derived in connection to FWC's business in the UK. And we accept that FWC satisfies the other specified conditions. It's all about the first condition. And as the judge said, there's no dispute that FWC was carrying on business. It's quite a thin business, but it was carrying on a business at the time. The question is whether the exception applies, given that the carve-out doesn't. It's not a bank, insurance company, or securities dealer, so carve-out doesn't work. Was it carrying out the business of making and managing investments for the resident's own account?
And when you say at the time we're concerned with is one, taking the assignment, and two, appointment of security trustee. Is that right? That's the moment at which we have to decide whether they're qualifying lenders.
It's only, I think, taking the assignment, because that is the point when the income is crystallised, if you like, the entitlement to the interest. But it makes no odds as it happens, because it's the same either which way. But I think it's probably only at the point of assignment, my lord.
Not sure I followed that. We're concerned, aren't we, with its status as an entity, rather than for ground 3, rather than what it actually does. Does that not equally apply to the security trustee provision? Maybe I've misunderstood.
We are concerned about its status, but it's still tied back to with respect to an item of income, profit or gain, even in here.
It's different to the ground 2 point.
Yeah. Yeah. And my friend Mr Robinson reminds me that the security trustee itself doesn't need to be a qualifying lender. We're only concerned with the assignment point. So that's the point at which it's relevant.
Yeah, okay, sorry.
Sorry, I misunderstood your question, Mr Robinson didn't. But yeah, so that we're only focusing at one point in time, which is the point of assignment. Nothing changes vis-a-vis this question once or if FWC becomes a security trustee or agent. So there's no dispute between my friends and I about the interpretation of treaties, and so I'll take it quickly and perhaps just give your ladyship and lordship the reference. It was set out most recently 3 months ago, post-dating all our skirted arguments in the Royal Bank of Canada case, which is in the authorities bundle at tab 27, page 709, set out by Lady Rose from paragraphs 27 to 33. I don't think I need to turn it up. There is an interesting paragraph about equally authoritative versions of treaties in 2 languages, because that's the case that involved Canada. I know there's a dispute about what the French and the English meant. Luckily, nobody is suggesting the Japanese version has a different understanding, as we might, well, speaking for myself, might struggle to interpret it. There is, as Lady Rose explains, the underlying requirement under the Vienna Convention on the Law of Treaties to interpret all treaties like this in accordance with the ordinary meaning to be given to terms of the treaty in their context and in the light of their object and purpose. And that's the start point, the ordinary meaning of the terms of the treaty. I only want to add to that one thing by reference to the authorities bundle, which is the words of Lady Justice Falk in the General Electric case, and this I will ask you to look at. It's tab 26 of the authorities bundle. And this predates Lady Rose's judgment in RBC, but Lady Justice Falk had been the judge in the Court of Appeal, or one of the judges in the Court of Appeal, in RBC itself. If you pick it up at paragraph 36, which is at page 674 of the bundle, Lady Justice Falk deals with the approach to treaty interpretation, refers to her own judgment in RBC in the Court of Appeal. I needn't take you through that, but it's a fair summary, if I may respectfully say so, and it is repeated by Lady Rose. Can I just point to 675 and paragraphs 37 and 8? Because Lady Justice Falk adds 4 points, and I only want to look at the first one. She says, first, the unilateral opinion or practice of a tax authority is not a relevant aid to interpretation. And you'll come to see later why I say that's relevant. Going back then to 22.5, our start point, we say the end point is, you just give these words the ordinary meaning, under, if needed be, with the assistance, if need be, of any interpretation by the courts on the UK tax legislation. But actually, you barely need to go there, because in Article 22.5, the only words we need to consider are carrying on a business, a very broad term that everyone understands. In English law, it's pretty difficult not to carry on a business. If you're not doing anything at all, or you're an individual enjoying your weekend, you're not carrying on a business. But pretty much any activity, certainly by a company, would be a business. There's authority on that, but I don't think that's in dispute. The only other words we need to focus on is making or managing investments, because, and I should make this clear right at the outset, the words for the resident's own account are not in dispute, because Millennium's friends accept that if, and I accept this as a condition of their acceptance, if in fact FWC was carrying on the business of making or managing investments, it was so doing for its own account. There's no dispute about that. Now, the carve-out doesn't apply, but it's important for the purposes of interpretation, which I'll come back to. So the point would seem to be a pretty simple question. The evidence was all one way. Can I just show you the evidence briefly? And before I do that, or while I'm getting the bundle, can I just say...
Before you do that, can I just ask this? So the purpose of 5, presumably is if you don't qualify on the residence basis
Yeah.
that earlier described,
Yeah.
then you qualify because you're carrying on business in the relevant jurisdiction.
Yeah.
So what's the purpose of the exclusion within the brackets?
I'm going to come to that in some depth, my lord.
Right, okay. Sorry.
Can I just show you the evidence, my lords and lady, on this? Mr. Weinstock's statement, which I took you to, is in the supplemental bundle at tab 6 and starts at page 166. What you will see in this witness statement, before I point you to the specific paragraphs, is that Mr. Weinstock, at least, thought that what he was doing was making and managing investments. Paragraph 2, I lost count of how many times he uses the word investment in this paragraph, but it's peppered with investment when he's describing what it is that FWCL, that's Fitzwater Capital Limited, is doing with the fund. Admittedly, he doesn't descend to FWC in that, but he's just talking about the structure of the company and what it does. It's a hedge fund. It's doing portfolio management, risk management, it has investments. The claimant, it says, and this is FWA, of course, is a subsidiary of the fund. That's right at the bottom of the page. You know as well that so too is FWC. If you then pick it up at page 168, paragraph 11, there's a section called FWC's business. Here is descending to the entity we're here concerned with. At Fitzwater Capital, that's not FWC by his definition, we predominantly manage third-party capital, which we've raised from external investors, including pension funds, etc. These funds provide capital in context of complexity, transition, and other special situations, support management in the unlocking of a company or asset's full potential. These special situations can include investing in over-levered businesses, either by buying the debt or providing new equity, providing capital for the establishment and growth of platforms, purchase of assets, which we believe are undervalued. FWC, he says, a subsidiary of the fund, incorporated in September 21, and I'll show you that it was for the purposes of this transaction it was incorporated, has since taken transfer of and holds a number of investments on behalf of the fund. At 14, FWCL acts as the manager of the fund and Fitzwater Capital Partners 2 and their associated feeder and co-investment vehicles. FWCL earns revenue by charging a base management fee and, if applicable, performance fee. FWC US acts as investment advisor to FWCL in respect of the FWC funds. Go over the page, you can see the table I took you to at 16. The VietJet related investment, which is the subject of the current proceedings, is held within the fund. It's one of the first investments of the fund. 17. The investment, which is the subject of these proceedings, was made by FWC, acquiring 4 loans. So if you'd asked Mr. Weinstock before he thought there was any litigation in train, did FWC make any investments in VietJet loans, he'd have said yes. Over the page at 21, you can see some of this I'm taking you to, so to save Lord Wilson time later, there's the reference to qualifying lender because he and others at the company or the group recognised FWC needed to meet the definition of qualifying lender for the purposes of the loan agreements, but he wasn't directly responsible. It was Andrew Gray that was responsible. He's employed by a partner by FWCL, previously had oversights of the fund's aviation investments. That's what he does. And then he was satisfied that they were a qualifying lender. But as the judge said in his judgment, they didn't think very hard about this particular point, whether they were or not. It would be fortuitous if they were, because they didn't think about this point. At 24.2, over the page at 171, Mr. Weinstock, no doubt assisted by his lawyers, is looking back when he wrote the statement at the qualifying lender requirements in the NEO loan agreement. He says at 24.2, status, at all material times FWC was a financial institution, well, query, that's ground 2, because it was a corporate entity established to trade and hold investments on behalf of the fund. That's what he thinks it does. At 25.3, he does the similar exercise. He talks about the main purpose of the entity. He says in 25.3, halfway down, in determining whether to make the investments and take transfer of the loans, I do not recall any discussion suggested as FWC was motivated in any sense by the availability of the exception. That's ground 4. I'll leave it to my Lord Wilson. There are then various other paragraphs I'm not going to take you to where the similar sort of language is used. As a matter of ordinary language, it's clear that FWC was making investments in the form of buying loans. There's nobody, if they weren't overly focused on the double taxation treaty, who would say otherwise. That's just what they were doing. And Mr Weinstock is pretty candid that that is what they're doing. Pick up his oral evidence, and he doesn't demur. It's in tab 4 of the bump.
Sorry, because we haven't really been shown much of the underlying material in relation to what FWC was doing. But you say FWC was buying loans.
Yeah.
Was it at the material time buying other loans on behalf of the fund, and how big was the fund, and what was the sort of scale of its?
As I'll show you in the transcript, FWC was set up for these transactions.
Yes.
And the first thing it did, and as far as we can tell, the only thing it did, was buy 4 VietJet loans.
So when you say you accept it was carrying on business,
yeah,
the business it was carrying on
was this business.
Was
this.
The business of the transactions with which we're concerned, and only that.
Yes. And you'll see that in the transcript, my lord. There is a question mark about whether there was a 5th potential investment, but at least 80% of the investments by count were the 4 that are before your lordship. And so there was, just to be clear, my lord, there was some discussion before the learned judge about whether this was carrying on a business at all, because immediately before it purchased the first loan, arguably it wasn't doing anything at all. But
we're not concerned with that now. That's gone.
That's done.
Yeah.
So, my lord, my ladies, you can pick it up in the transcript at tab 4. I don't know if I've answered your lordship's question. At tab 4, there's the transcript, and we start at page 40. Some of this I'm going to go through to save Lord Wolfson the trouble later, but pick it up at page 32 of the internal documentation, right from the top of 32. In the normal way that the fund is constituted, you've got the advisors, you've got the fund, you've got the limited partners, you've got the general partner. Yes, it's Lord Wolfson asking Mr Weinstock. These companies are based in a number of different jurisdictions, aren't they? They are, yes. US, Jersey, Cayman, Ireland, I think, probably have to remember, but possibly. And you're able to set up a company in more or less any jurisdiction you want, if that's the most advantageous way of structuring a transaction, yes. For example, you set up FWA in Jersey for the purposes of requiring the rights in relation to the aircraft in this case, yes. And when you decide how to structure a transaction, taxation is one of the aspects you typically take into account, isn't it? It would amongst others. I mean, well, it's almost unthinkable to plan and execute a major investment like this without taking into account tax consequences and the effect of the relevant tax regime. Sure, yes. Then down at 15, I'm very grateful. In this case, you decided that the company which would take the assignment of the loans would be FWC. Yes, that's a UK incorporated company. I'm sorry, when you're referring to financial trading, yes, so because FWC is an abbreviation for the company that has financial trading in the brackets in its name. Was it you that made that decision? No, it wasn't. Who was it? I think it was probably Andrew Gray in consultation with Esther, who's our Chief Operating Officer, and Joe, who's our Financial Controller, probably with external advice. I don't know if we got external advice, very possibly. Esther Gaywin or Scott, who's our COO. She's based in London. We spoke 3 days ago. Is there any reason she couldn't give evidence? It was Joe plus Andrew. It's fair to say, if I wanted to know why a UK incorporated company was chosen for this element of the transaction, I should really be asking Mr Gray. Forgive me for using their first names, Esther, Scott, or Joe. Is that fair? I'm sure that's fair. I'll give you generalities, but not specifics. But it was specifically set up for this deal, wasn't it? I think it was incorporated 24th September 21. That sounds right. It is right. I'm just trying to think if we did anything else through that previously. No, that sounds right. And its articles say its purpose is to carry on the business of a financial institution and dealer. Jump forward, please, to page 37. Picking it up from 3rd line down. To carry on FWC says its business is to carry on the business of a financial institution and dealer, including the provision of investment management services to funds as an investment manager. That's why I hesitated when describing FWCL as being the investment manager, the only one, because FWC says its business is to do that. It's halfway down the page in very small type. Now, FWC holds investments on behalf of the funds, correct? Yes, it does. And that's because it's owned by Master Holdco. That's the Jersey company immediately above, if you remember. And then 38, line 5, you refer at paragraph 13 of your witness statement to assets. FWC isn't the investment manager, though, is it? It's an entity that holds assets. Yes. It doesn't carry on the business of a dealer. It holds assets as a subsidiary of the fund, correct? Holds. It buys and it sells in cases too, like it did with the other one. But when it buys and sells assets, it's doing it for its own account, yes? For its own account, I don't know exactly what own account means. There's a short exchange about that, and pick it up at the top of 39. So the point I'm putting to you is that when FWC was doing its business, it's not the business of dealing, it's holding assets as a subsidiary of the fund. It's making investments and trading in assets, and then it's on behalf of the fund ultimately. So I'm not exactly sure what your question means. Apologies. That should have been it. There's not much doubt then in the evidence, and probably you wouldn't even need the evidence, that this is precisely what FWC does. It's making and managing investments for its own account. If you need a more nuanced construction, you need to look at the object and purpose of the provision. That's clear from the Vienna Convention. And the object and purpose of the Double Taxation Treaty, set out very helpfully by my Lady Justice Falk in the General Electric case, but I'm not going to go to it. She sets it out from paragraph 75 if you want some more background reading. It doesn't help on this article. It's describing why countries enter into treaties such as this, the general idea. It doesn't also answer this question, but I'm going to attempt to answer it. The question is, why are private companies that are owned and controlled by non-residents a concern for the drafter of the treaty? And the answer in my respectful submission is clear. It's very easy to incorporate companies. It's not so easy to create individuals or government entities or banks. It's very easy to create small companies, usually a very simple process in developed countries. Governments don't want people outside their own states in countries with which neither of the states have agreed their own DTT, incorporating companies within the UK or Japan, and so obtaining treaty relief which they wouldn't otherwise be entitled to. That's the point of the restriction. We can see that from the guidance to the OECD Model Tax Convention. And for that, I need to ask you to look at tab 28 of the authorities bundle. And I should say, as you're turning that up, that it is clear from various Supreme Court decisions that looking at the guidance produced by the OECD can be an aid to construction. And that is so even if the guidance postdates the treaty. But in this instance, I'm going to look at the 2005 guidance, which actually is the year before the treaty was made. And that's not because I don't like the guidance later, it's just because it's actually more comprehensive on this point. At page 741 of the bundle, starting at paragraph 7, is a section on improper use of the convention. And it sets out this guidance, the principal purpose of the Double Taxation Convention, to eliminate international double taxation, exchanges of goods and services, and movement of capital and purposes. 7.1. Taxpayers may be tempted to abuse the tax laws of a state by exploiting the differences between various countries' laws. Such attempts may be countered by provisions or jurisprudential rules that are part of the domestic law of the state concerned. At 8, over the page, it's important to note the extension of double taxation conventions increases the risk of abuse by facilitating the use of artificial legal constructions, companies, aimed at securing the benefit of both the tax advantages available under certain domestic laws and relief from tax provided for in double taxation conventions. This would be the case, for example, if a person, resident, whether or not resident of a contracting state, acts through a legal entity created in the state, essentially to obtain treaty benefits that would not be available directly. If you go forward then to 9.5 over the page, with the red lines on the side of it, it is important to note, however, that it should not be lightly assumed that a taxpayer is entering into the type of abusive transactions referred to above. The guiding principle is that the benefit of double taxation convention should not be available where a main purpose of entering into certain transactions or arrangements was to secure a more favourable tax position, obtaining that more favourable tax treatment in these circumstances would be contrary to the object and purpose of the relevant provisions. That's the touchstone, if you like, of the abusive transactions test. Then 9.6, the potential application of general anti-abuse provisions does not mean that there's no need for the inclusion in tax conventions of specific provisions aimed at preventing particular forms of tax avoidance. Where specific avoidance techniques have been identified, or where the use of such techniques is especially problematic, or probably common as well, it will be useful to add to the convention provisions that focus directly on the relevant avoidance strategy. So you can have your general anti-avoidance provisions, but if you know there's some particular way people tend to use, put in a provision that shuts that door as well. Above 13, you see a section of this report that runs to about 9 paragraphs, headed Conduit Company Cases.
Mr. Thompson, this is all very interesting
Yep.
and useful background, but we have to answer these specific questions
Yes.
in a specific case. So
Yes.
do we have time for this?
I hope we do. I'm going to take it as quickly as I can, and maybe even more quickly, given your ladyship's encouragement. But you can just see, and I'm just going to skim over, if you glance at 13 and 14, you can see a look-through approach. There's a way of excluding conduit companies, different ways of excluding conduit companies are set out. And then at paragraph 20, this, whilst the preceding paragraphs identify different approaches to deal with conduit situations, each of them deals with a particular aspect of the problem commonly referred to as treaty shopping. States wishing to address the issue in a comprehensive way may want to consider the following example of a detailed limitation of benefits provisions aimed at preventing persons who are not residents of either contracting state from accessing the benefits of the convention through the use of an entity that wouldn't otherwise qualify. And then there is, from 748 and 749, a model provision, a model clause, which is not identical, but very, very similar to Article 22. In that at paragraph 2, it sets out residents who can benefit from the treaty. And at 3, it says a resident of a contracting state will be entitled to benefits with respect to an item of income derived from the other state, regardless of whether the resident is a qualified person, if the resident is actively carrying on business in the first mentioned state, other than the business of making or managing investments in the resident's own account, unless the activities are banking, insurance, or securities activity carried on by a bank, insurance company, or resident securities dealer. That is, in essence, almost identical, I think, give or take a word or two, to Article 22(5). And so that is either the model which was identified or is certainly the one that the commentary touches upon. This is the comprehensive way to deal with treaty shopping. The guidance goes on to talk about other suggestions, and Lord Wilson may touch upon that, but I needn't go to that. Now, as I say, all of that simply indicates, in my respectful submission, that the answer to this question is clear. Because this is precisely the sort of person for which there is Article 22(5) established in the first place. It is intended to stop conduit companies. And if you set up a company in the UK that's owned by non-residents, Jersey company or other non-UK or non-Japanese entities, then your ability to take advantage of the treaty is limited to the circumstances where you're actually carrying on a business. You've got to be doing something, but not managing or making investments, unless it's a bank, basically. And the reason for that is relatively clear, and I will, that's my Lord Zacaroli's question, it is relatively clear, and I'll come to why it might be. I will simply float out now. The answer is because, as suggested in the guidance, this is the sort of technique people do. When you're talking about making and managing investments, it's very easy to do from anywhere. You can do it with a computer. If you're trading in widgets or spoons or antiques, it's quite difficult to do just by setting up a company in one country and carrying it on. If you set up a bank, you can't do that overnight. But if you set up a company that just makes and manages investments, you can do it at the click of a switch, all online, and set up a UK company which then makes and manages investments. So
I think you're back to Belsize Park, Mr. Thompson.
It's a different point to Belsize Park, but obviously the Belsize Park company is the object of this sort of provision, the Belsize Park company.
No, sorry, I was just being...
No, it's a fair point, my lady. I think the Belsize Park people probably would be caught by this. But can I just make the distinction now between what I've just said to your lordships and lady, which is that this is a very simple question, with the way in which the judge approached it. The judge thought that the relevant question was whether FWC were engaged in any venture in the nature of trade. If you pick up his judgment at page, bundle, you go back to the core bundle and look at tab 5, it's page 128, thank you. This is the judge's analysis. At 256, he said, as to the meaning of making or managing investments on its own account, the notes to the application for relief under the DTT published by the Japanese tax authority state the following. Now, firstly, Lady Justice Falk would have told him that can't be an aid to construction because it's the opinion, or not even the opinion really, but the wording on a form of a single tax authority. It helps you not at all. And then Mr. Shah's observation that guidance is consistent with the distinction in English law between income derived from an adventure or concern in the nature of a trade and investment business, namely the holding or managing of investments. See Bramwell. There's an oddity about this quote, because Bramwell paragraph A813 wasn't actually shown to his lordship. It was shown 811 and 812, but none of the three paragraphs say anything more than this. Investment business, I accept, is holding and managing investments. So the second half, the last two lines of that paragraph, are supported by that book. But Mr. Shah's other observation, the important one, isn't. I don't think Malone and friends will demur from that. Then the learned judge relies on HMRC and Burlington loans and refers to paragraph 44. Paragraph 44 of Burlington doesn't say the words in italics. All Burlington says is you can look at OECD guidance, it actually says materials, when interpreting a treaty. But we know that from Lady Rose. The guidance has the following to say. Now, just pausing at this point, can I just make clear, this is not an OECD commentary that the learned judge is citing. It's a report. And Lady Rose, at paragraph 32 of the judgment for what it's worth, citing Lord Briggs, at paragraph 16 of the authority you have at paragraph tab 20, Fowler, made clear that if you're going to interpret treaties, you can look at the OECD commentaries, not any documents that the OECD has ever produced. And to that extent, Burlington overstates the position. It's the commentaries, and that's what I took you to. That was a commentary. The learned judge quotes a report. And so in my respectful submission, you shouldn't be looking at it at all. But even if you were, it doesn't say what the judge says it says. The judge said this distinction between an income derived from an adventure or concern in the nature of a trade and income derived from an investment business is clear from that paragraph. With respect to the judge, it doesn't. That paragraph refers simply to, or paraphrases, what Article 2.5a says. It doesn't actually take matters any further at all. Paragraph 2.5.8, the judge said this, as Mr. Shah explained, there's no decided authorities on the DTT by the English courts. Well, that's simply not right. There are quite a few. There are none on Article 22.5. There are quite a lot on the treaty. My own friend Mr. Peacock's been in most of them, I think. And then he says, however, with Article 3.2 in mind, and considering the meaning given to the relevant concepts under English law, the relevant distinction is between income derived from any venture in the nature of a trade and investment income. But that's focusing on income, and we're not dealing with income at the moment. We're dealing with whether you're making or managing an investment. Income is a subsidiary point that we don't need to focus on for the purposes of this question. And in fact, there is no such distinction, and it's not relevant. This isn't.
Why don't we need to focus on income? We're only into Article 22
Yep.
via Article 11, which
Yeah.
is concerned with debt income.
That's right. But the actual questions we're focusing on, the only questions we need to know is whether FWC is making or managing investments. That's the only question. That doesn't turn on what its income source is. What the judge is saying is, in order to answer that question, we need to consider what is the distinction between income from a trade and income from an investment business. And that's a false distinction. You don't need to answer that question.
So how does this provision apply where you have someone who is carrying on investment business and other business?
Well, if you are making and managing investments for your own account, then in respect of the income that you derive from that, which is what Article 22.5 says, then you can't take advantage of it because you're in the exception unless you're a bank. But the point is, my lord, the critical problem with the learned judge's distinction is that trade and investments are not mutually exclusive activities. They're in fact, you can do one, you can do the other, you can do both, and you can do neither. So a bank, for example, does both. It clearly is trading when it makes loans and carries on its day-to-day business.
Sorry, can I just go back to your previous answer?
Yeah.
So 22.5, when it says, with respect to an item of income, profit or gain described in those paragraphs, is applying a test which is referable to the aspect of the business which gives rise to that income, profit or gain, is it? Rather than more generally the business being conducted by the entity.
No, sorry, I didn't mean to say that. It is the business that's being carried on.
Because how does it then work for a business that is, leave aside what's meant by making or managing investments, that is doing both?
I'm not sure.
Does the last four lines of 5 help? The income, the relevant income must be incidental to that business. So it must be the business other than investment business.
Well, no, because I think those lines are dealing generically with the connection between the income, that profits and gains that you're receiving. So if you're receiving income, profit and gains from Japan, it must be somehow incidental to your UK business. It can't be completely unconnected. And I apologise for being unable to answer my Lord Popplewell's question, but Lord Justice Popplewell's question, I think the reason I can't answer it is because, well, the main reason is I haven't thought about it, but I haven't thought about it because it doesn't matter in our case. And it doesn't matter because, in our case, it's quite clear that it was making and managing investments and carrying on investment business. Whether it was trading or not, and the judge thought it was, doesn't change the answer to that question. And so my point is, these are not mutually exclusive ideas. You can trade and be making and managing investments. That's what a bank does. You can be just trading, an antiques dealer. You could be doing neither by painting, or you could be just making and managing investments. You're day trading. So it doesn't matter if you're trading, and the answer to the question, are you trading or not, doesn't inform the question that we're faced with, which is, are you making or managing investments? And that's the error that the judge made, because he simply said, I have determined that they are trading, which may or may not be right. Ergo, he said, they weren't making investments. It's a false distinction. And Malone and Friends are going to try and persuade you, albeit I think somewhat reluctantly, that it's a fair distinction, but they won't be able to show you any authority which says it is. There are cases in which it might have been important to discern whether it was a particular activity was trading or an investment. Obviously, some particular activity, some particular item, transaction might be a trade or it might be an investment. There are cases about that, but that doesn't determine that these are, by definition, mutually exclusive activities.
Can I just ask for your assistance as to quite how you go about defining an investment? You've said to us what this is intended to catch are people who do something from a computer in one country very easily.
Yeah.
So does that mean it doesn't catch capital investment in immovable property, stamps, antiques, cars?
Well,
what is the criteria?
Yeah. Well, so the criteria is just making and managing investments, and it doesn't matter whether they're financial investments or other ones. But what has happened here, in my submission, it's a direct example of what you saw in the guidance, which is that the states have identified that there are particular techniques which can be used very easily to avoid the benefit, to try and gain the benefit of the treaty without being substantively associated with either country. And that's what it's trying to focus on. So to answer my Lord Justice Zacaroli's question, that's why it focuses on making and managing investments, because those are the sorts of things that the governments have presumably thought, well, that's pretty easy to set up.
Can I just press you a bit?
Yeah.
Because investment is potentially quite a wide and loosely used term, and you say we must look at it as a matter of normal language.
Yeah.
And most people would say, if I buy a house in Japan in the hope that in 10 years' time it will have increased in value, I'm making an investment. Is that covered by this?
Well, if it's a business, yes, there has to be a business. You only get into this world if you're a business in the first place.
Right.
So if your business is making investments in another country...
Well, I've incorporated a company in order to do so.
Yeah.
And as you've suggested,
if
you've got a company, pretty much anything it's doing would be treated as a business. So that's what I've done. I've incorporated a company in order to buy this property in Japan, making investment.
Well, I think that might be one of the few examples where it's not a business, because if you simply do it because, in fact, you've seen a particularly nice flat in Tokyo which you wish to acquire and you think it might make you some money, that probably isn't a business, and it may not even be an investment, but that's a whole separate category of problem. What we're actually talking about is entities that are just clearly making investments, and I don't shy away from the fact that you might be able to find businesses and things, conduct that's carried on that are very close to the line of whether it's an investment or not, and indeed whether it's a business or not.
I know you say never mind where you put the line. It's obvious this is way one side of it. And I understand the submission, but I'm just trying to understand what is a matter of interpretation.
Yes.
We should be saying this carve out is intended to cover and isn't intended.
Can I take a step back to answer your question in that case, my lord? If you imagine a company that's set up by non-residents in the UK that does something nothing to do with investments, let's say it's trading in spoons, and it then goes to a spoon fair in Tokyo and sells some spoons, it can take advantage of the treaty because it's got a business in the UK. It doesn't come anywhere near the exception or the carve-out. It's make money incidental to that business in Japan and doesn't have to pay tax in Japan, pay it in England.
It's obvious that's not an investment, but if the trader says, I not only buy and sell them immediately, but I hold on to them for 5 years if I think the price of antique silver is going to go up, well, the trader would say, I'm making an investment in antique spoons.
Well, as I say, there are going to be cases where, on the peculiar facts, it may be critical to understand whether or not you're making an investment. And there are cases where the answer to that question is, if it's no, the alternative is trading. Those are some of the film cases, for example. You do have situations where a particular item of income or a particular transaction is, as a matter of fact, either going to be a trade or investment. It depends on the intention, no doubt, of the person at the point of acquisition, what they're actually doing. So I accept that there are instances in the case law, and indeed generally, where there is, as a matter of fact, that question that needs to be answered. But that doesn't determine this question, because what the judge said is when you can elevate that fact, the fact that there are situations, just as your lordship proposed to me, where the distinction is key, to a general principle that whenever you are trading, you are not making an investment. And the reason that that is obviously wrong with respect to the learned judge is because of banks. And so, with respect to your lordship, you don't need to focus on whether there are instances of companies that might be doing one or t'other and you need to work out which. What you need to focus on is the fact that there are companies that can do both. And as soon as you find a company that does both, it's proof that they're not mutually exclusive concepts. And given that actually what is talked about in these brackets entirely is about making and managing investments, and given that the carve-out to the exception is about banking, insurance companies and security dealers, the clue's in the name, you can see that the draftsman is recognising that in fact you could be trading whilst making an investment, because a security dealer evidently is trading, and so is a bank.
So is the carve-out mean that the sort of investments you're talking about are limited to those which could or would be made by those carrying on banking, insurance and securities business?
I don't think it's quite that narrow, but those people would certainly be caught. I take your point, my lord. I mean, does it catch, if I can paraphrase your question to make sure I've understood it, does it catch people who are making investments, things that have nothing to do with what banks, insurance companies and securities dealers do? I think it probably does. But again, with respect, I don't think we need to answer that question, because you've actually got before you an entity which is doing precisely the sort of investments that those sorts of companies do. We are focused on a financial investment transaction.
So the answer to my question earlier was the reason for the exclusion within brackets is because those are the sorts of transactions which can be done by pressing a button when you're abroad.
That is, and I should make it very clear, that is my submission.
Yes.
I cannot point you to anything in terms that says that. It is, however, useful to point to the carve-out to the exception, as I call it, to see that banks, insurance companies and securities dealers are still permitted to take advantage of the treaty.
Yeah.
Because those sorts of entities can't be just set up on a whim. They're mainly regulated. Right. Yeah, sorry.
What about if I set up a company which, to carry on a business of buying and selling investments that can be bought and sold by pressing a button on a computer? That falls foul of your rationale, doesn't it? But yet would be carrying on a business, wouldn't it? Because it wouldn't fall within the exception. But
that is the sort of company which, that's what the judge thought this company was, that would be caught because it's doing both. So in the course of...
So it would be caught by the exception?
It would be caught by the exception. It couldn't take advantage of the treaty because it is simultaneously, at one and the same time, trading and making and managing investments. That's what a bank does.
But buying and selling would not be managing and making investments.
Well, if what you're buying and selling are investments, then yes. Because if what you're buying and selling, let's say what you're buying and selling is futures contracts or loan debt, you are making investments. You're just making investments and selling them again.
But an investment isn't a thing, is it? You're buying and selling some item of property, some asset.
Yeah.
Spoons could be an investment on that analysis, but they're clearly not, are they? Well, they might be for somebody.
Well, this is my Lord Justice Popplewell's question, which I sidestepped on that front. But they are investments in that sense, because when this exception is talking about making and managing investments, read in the context of the carve-out to the exception, it is, in my respectful submission, talking about precisely these sort of financial products. That's what, as a matter of ordinary language, people say when you're making investments.
Do we have to frame this debate by reference to the kind of transactions that fall within its scope? That is to say, royalties, capital gains on shares, debt income by way of interest, and so on. Because if, for example, it's just trading by way of an enterprise, you're into Article 7 and you're not concerned with any of this.
Yeah.
So that the investments which are capable of coming within the whole are to some extent limited by the articles to which this applies.
Yes. Well, I accept that, and of course they aren't all of them.
Is it right?
Yes, I think it is right, with respect, my lord. Obviously, royalties is a relatively simple one. You can make and manage an investment, or you can certainly make an investment and then derive royalty from it. So that's a relatively straightforward one. But as your lordship pointed out to me, there's also Article 21, other sorts of income, and 13, which is capital gains in essence. But I accept that, my lord. But all of those, I mean, you can derive from investments things other than interest.
I mean, take royalties, for example.
Yeah.
One might think that what this court used to call popular artistes are not making investments in the royalties that they get, but those who, as is now not uncommon, buy up the back catalogue of popular artistes, one might think were making investments.
I think there's a specific article about entertainers and so on at 16. But if you're
right.
So that might be
maybe that's not the answer. But,
slightly more complicated.
And I'm only throwing that as a problem rather than a solution. But it illustrates that if one's trying to identify what is meant by an investment.
I accept that, my lord. But at the risk of repeatedly trying to sidestep your lordship's question, I don't think we need to answer it. I dare say Mr Peacock will be able to, maybe not in terms I'd agree with, but I don't think it matters. Because if you are focused simply on the sort of investments which a bank, insurance company or securities dealer does, let's say that's exactly what you do, but you aren't a bank or company, insurance company or securities dealer, you are definitely not allowed to take the benefit of this convention. And that is the long and short of this case.
So, would I be correctly paraphrasing that submission, that although investment may be wider than those things which a bank, insurance company, and securities dealer would do, it certainly includes anything that those entities might ordinarily do?
It must do, my lord, as a matter of logic, because if it didn't, you wouldn't need the carve out. And that's why I'm so ill-equipped to answer your lordship's question, because fundamentally the answer to the question for your lordship and your ladyship is as straightforward as that. As a matter of logic, on the reading of the article, this entity is not allowed to take advantage of the treaty, and the judge's diversion to consider the question of trade was completely irrelevant, because it's not a distinction that matters. As I say, you only need to think about banks, or for that matter, security dealers. If there is an entity, you can prove the point simply, it's a matter of logic. If there is an entity which trades, but is also considered by the article here to be making and managing investments, such as a security dealer, then that demonstrates that you cannot answer whether somebody is making or managing investments by answering the question, are they dealing?
It's not a dichotomy.
It's not a dichotomy.
But it might still have some slightly surprising results.
Well,
the bank buys a lot of rare pictures for its pension fund investment.
Well, if it's doing it as part of the business of banking, it's fine because it's in the carve-out.
Yes, but if someone else is buying rare pictures, that on this submission would also qualify as an investment because it's something that a bank could do.
Well, it might do, but you've got to. I fall back on the guidance because, as I say, these provisions are put in because they're trying to identify things that do happen, techniques that people do use to take advantage of treaties. The more outlandish examples that we think of, the less likely they are that the states, when they're negotiating the treaty, think to put them in. They might be theoretically possible, but there's not really a tax concern for the revenue whether people are doing some of these more esoteric activities. What is a problem is people setting up two-bit investment companies.
I've taken too much of your time. Thank you.
I hope it was useful, my lord. And it probably saves me from some. Can I just have a moment? I think I can rush through quite a lot of what I was going to say because I think we've dealt with it. Perhaps I can just demonstrate again why not only did my lord Mr Justice Picken start at the wrong place, he then demonstrably ended at the wrong place. If you go back to the judgment, I pointed out that the learned judge pointed to authorities that didn't support his distinction. He then dealt at paragraph 259, that's page 128 of the bundle, with the tax cases, but again, they don't take matters further at all. He then dealt with Lord Wilson's submissions at 263. Can I just remind the court what Lord Wilson submitted? It's plain that Fitzwater did not come within 22.5. He observed first, as he put it, it's at the very least debatable whether or not FWC is a newly incorporated company which had not previously entered into any transactions at all can be said to have bought the VietJet loans in the course of a business within Article 22.5. Now, we're not pursuing that point. Recognising that wasn't a complete answer, Lord Wilson went on to submit that even assuming in FWA's favour that it was carrying on business in the relevant sense, the business was plainly consistent of making or managing investments for its own account in circumstances where FWC made the investment on its own initiative with its own funds and the debt arising from the investment was shown as an asset on the balance sheet. Indeed, Lord Wilson commented, FW's own pleaded case makes no suggestion that they purchased on behalf of anyone else. That's no longer an issue. Nor, he added, did Mr Weinstock really dispute this, really expressing uncertainty. And then 3 lines from the end, 4 lines from the end. However, Lord Wilson suggested that the fact that FWC was a subsidiary of fund does not mean not make the investments on its own account. He went on to submit, even if FWC could be regarded as having made the investment on behalf of the funds as opposed to on its own account, that would not avail FWA because it would not then be beneficially entitled. Now, the judge didn't accept any of those submissions, but apart from the first point about carrying on the business, that's now common ground, basically conceded. So it's only the last point. And here, just look at the judge's analysis. On the contrary, he says at 264, I agree with Mr Shah, the relevant exception reflects that the entities in question, banks, insurance companies, security dealers, will in certain circumstances make or manage investments on their own account. For example, an insurance company will be engaged in trade, provision of insurance, but may also hold investments as collateral. Likewise, a bank may provide banking services such as mortgage loans and bank accounts, but also hold investment securities as collateral. It does not undermine that distinction that applies as a matter of generality under UK tax legislation. Specific reference to those types of entity should not be taken as doing anything other than putting the position beyond doubt. But with respect to the learned judge, this isn't an article that's trying to put matters beyond any doubt. This is the core of the article. The core of the article is asking you to consider what people are and are not entitled to under the tax treaty. Are they making and managing investments? And if they are making and managing investments, are they doing that business as a bank, insurance company, or securities dealer? So it isn't just putting the matter beyond doubt. It is actually defining what it is that is and is not allowed. And the carve-out from the exception gives lie to the judge's analysis, as I've already submitted. And more importantly, the judge's approach doesn't actually give any weight to the obvious intention of the treaty, which is to ensure that those entities which are carrying on business like a sort of bank or like an insurance company or like a securities dealer, but which are not banks, insurance companies or security dealers, should not qualify. If you are a faux bank or a faux securities dealer, you definitely don't get the benefit of the treaty. And the judge's analysis doesn't give effect to that, because you just say you're trading. Just briefly then, my learned friends Skeleton argument have 3 points on them in answer to this. The first point's not really an issue. They say, sorry, I should give you a reference. It's tab 9 of the core bundle, and it's let's take it up 200 first, please. They have 3 points that they summarise in paragraph 47. I can probably do it just from 47. It betrays a fundamental, our case betrays a fundamental misunderstanding as to which entity needs to satisfy the terms of 22.5. And at 48, there are references in our skeleton argument to different entities and groups and so on. There's no problem here. Whatever the language in the skeleton argument, we accept and understand the entity we are focusing on is FWC. That is clearly the case. That is the entity that made these investments, as I would say. So that isn't a point. But you cannot ignore the fact that FWC is within this group, because as Mr. Weinstock makes clear, the whole group, which probably has more entities than human beings involved, is actually involved in all of this investment business. You have the managing partners, the general partners, the funds. These are companies that don't have hundreds of employees. They're just companies that were all set up in 2021 to make, frankly, this investment. They've made others since, as we understand. But this is a group of companies where they have the different entities in different tax jurisdictions, no doubt for different tax benefits, conducting a hedge fund. But it isn't, so you cannot ignore what FWC does, its role within the company, within the group. The rest of my friend's skeleton argument is about whether the judge got his analysis of Article 22.5 or 22.5 right or wrong. Just pick it up, please, at paragraph 51. 201. My learned friends say this: Article 22.5 thus ensures that an enterprise that's a resident of the UK is entitled to receive interest without deduction of withholding tax in Japan, where the UK lender carries on a business in the UK, and provided that that business is either a non-investment business, brackets a trading business, e.g., or if an investment business, that business is then either business of managing investments on behalf of others, yes, true, because the others will have to suffer the tax consequences, or if the business is one of managing the enterprise's own investments, the business is banking, insurance, or security dealers. Now, firstly, if you ignore the words in brackets, that is an unobjectionable, indeed logically impossible to argue with distinction, because A is non-investment business and B is investment business. They are truly mutually exclusive things, non-investment and investment. But it's the e.g. trading business that is the sleight of hand, and that's what the judge equates. So the judge is equating trading business with non-investment business. And actually then in paragraph 52, my learned friends then build on the judge's error by then equating sub silentio non-investment business with trading business, which in 51 they had recognised was just one being the example of the other. I'm not going to go through my learned friends' cases, but I will submit when you look at them, if you look at them with the correct principles in mind, they don't help him at all. In fact, one of them, I suggest, nuclear electric, actually helps me. I'll deal with it in reply if I need to. At the end of the day, it doesn't matter whether, as the judge found, FWC was carrying on a trade. We argue the point in our skeleton argument, but I'm not going to take up your time today. It simply doesn't matter if it was trading or not. What matters is whether it was making or managing investments. And despite the interesting debates we can have about what does and does not amount to making or managing investments, this company certainly was. That's ground 3, which has taken me much longer than I was allowed, even accounting for the fire alarm. I'm going to stop unless your ladyship or my lord have any questions on ground 3. Hand back to...
Thank you, Mr Johnson.
We'll have to take stock on time in due course, I dare say, but I apologise for overrun.
Article 11, ground 4.
My lady, my lords, I'm going to try and get through this before the short adjournment, if I possibly can. Let's start with the relevant provision of the double tax treaty, the only one that's relevant really for this, which is Article 11, its authorities, tab 3, page 8. And the court has seen this. Article 11.1 sets out the relevant benefit under the treaty dealing with interest, and this is subject to the proviso, so to speak, in Article 11.7, which is that no relief is available if it was the main purpose, or one of the main purposes, of any person concerned with the creation or assignment of the debt claim, in respect of which the interest is paid, to take advantage of this article by means of that creation or assignment. And so, for the purposes of ground 4, the key question was whether Article 11.7 was applicable, and we see that from paragraph 267 of the judgment, where the learned judge sets out the question. And if it was at least one of the main purposes of any person concerned with the assignment of the loans to FWC to take advantage of Article 11 by means of that assignment, then the requirements of clause 9.1A3 were not satisfied, because this is how we get into this whole debate. And it would follow that FWC was not a qualifying lender, as I submitted yesterday. Now, we summarise the relevant evidence at paragraph 59 of our skeleton. My learned friend has taken the court to it. I won't go back to it, but just to remind the court of one point that you saw in the transcript, that Mr Weinstock accepted that FWC was specifically incorporated in the UK for this deal, and the court has seen that material. The learned judge gave 2 reasons for rejecting my case on this. The first was that by the time that FWC took the assignments, the leasing of the aircraft had terminated and the loans had been accelerated, so there wasn't going to be any interest coming through so as to engage Article 11. And we submit with respect that approach is plainly wrong. Whether FWC actually expected to receive any interest cannot be relevant, at least for the purposes of deciding whether or not FWC was a qualifying lender under the loan agreements. The learned judge's logic appears to have been, since no interest was payable going forward, it can't have been a main purpose of FWC to take advantage of Article 11, because if there's no interest payable going forward, there's going to be no tax charged on any interest, and therefore it can't be part of FWC's purpose in taking the assignment to take advantage of Article 11 of the treaty. That's certainly my understanding of the learned judge's argument, or judgment, I should say, with respect. The problem with that, in my respectful submission, is that if you apply the learned judge's approach to the rest of clause 9.1a of the loan agreement, which is how we get into this in the first place, then FWC wouldn't be a qualifying lender at all. And of course, if it's not a qualifying lender, it can't take an assignment of the loan. And just to make that point good, if we go back to the loan agreement, which is at Core Bundle 15.409, or for my Lord Justice Popplewell, Supplementary Bundle 8 at 248. Looking first at the beginning of the definition of qualifying lender, sorry, 409 and 248. A qualifying lender must be a lender, quotes, which is beneficially entitled to interest payable to that lender. And if one says, as the learned judge did, that the loans have been accelerated so there's no prospect of interest arising, then FWC on this approach wouldn't be a qualifying lender in the first place. It wouldn't be beneficially entitled to interest payable, because no interest would be payable. The same point.
Is that right? Isn't there a default interest provision?
I didn't. Yeah, I didn't think there was a default interest provision on that point. Can I check that over the short adjournment? The similar point, and it's really the same submission I've made, but I can make the same submission when I get to Z. In other words, if FWC isn't going to receive any interest, then it can't be said that FWC benefits from the double tax treaty. Now, the same problem would arise under the CO loan agreement as well. Just to give the court the reference, core bundle 16442, supplemental bundle 9424, because the language there is that the qualifying lender has to be beneficially entitled to interest payable. But my essential submission is, so to speak, you can't have a heads I win, tails you lose approach to this, because what the learned judge's approach really does is to say, for the purposes of part of the definition of qualifying lender, you ignore the fact whether or not FWC would qualify for relief, because there's no prospect of interest arising. But for the earlier part of the definition, you assume FWC was entitled to receive interest, subject to the point which my Lord Justice Popplewell has put to me, and I'll come back to if I may. And we respectfully submit that, so to speak, it's one or the other. Either FWC is not in scope at all, in which case it loses for that reason, or it is in scope but it loses because of 11.7. That's essentially my submission. I apologise for taking this a little quickly, but I hope the court has grasped the burden of my argument. Turning to the second reason given by the learned judge, which is at 278 of the judgment. I won't read it out, but this is to do with the main purpose, or one of the main purposes, and the court sees that the judge adds the emphasis there. Dealing with the first point the learned judge makes there, the mere fact that Fitzwalter sought to structure its affairs in a tax-efficient manner. As we noted in our written argument at paragraph 64, this is, with respect, a little difficult to understand. As the court has seen, it's not the way I put it in submissions. It's not how I questioned Mr Weinstock. Incorporating FWC in the UK was, on its face, a tax-inefficient thing to do, because there were lower tax rates in Jersey, as I pointed out to Mr Weinstock. There was no suggestion at trial that FWA was motivated by any tax considerations other than those under the double tax treaty. And if the learned judge, secondly, was referring to relief under the double tax treaty, that's difficult to reconcile then with his previous paragraph, where he referred to there being no prospect of interest arising under the loans. Now, according to the learned judge, he says this doesn't bring 11.7 into play because he seems to have concluded there wasn't any relevant main purpose for the purposes of Article 11.7, and so we didn't meet the requirements of that article. And he said, it quotes, it could not safely be concluded that Mr Gray or any other uncalled witness would have given evidence which would have enabled it to be established. Now, at this point, I have to say, when I say with respect, I really mean it, because I'm going to say that the learned judge does not explain at all why he reached that conclusion. I mean, it isn't that the reasoning is brief on that point, it's non-existent on that point. And we do submit that the decision is unsustainable. My learned friend says, I can't take this point because it's an attack on a finding of fact by the learned judge. We rely, as the court has seen, on the approach of Lord Briggs and Lord Kitchen in the lifestyle equities case. I'll just give my lords, my lady and my lords, the reference. It's Authorities 23 at 580, in particular paragraph 49, and we respectfully submit that the appeal court is not precluded and is not powerless to intervene when faced with a decision of this kind, or perhaps I should say a decision reached in this way. We say that this is a case where the judge was, to pick up the language of that decision, plainly wrong, or made a significant error of principle. And the only, we submit, rational conclusion the judge could have drawn was that at least one main purpose of the assignment to FWC was to take advantage of Article 11 of the double tax treaty. And we submit that there is no proper basis for drawing a distinction, which this may be what the learned judge was doing, between where a party seeks to take advantage of Article 11 by collecting a benefit accorded by the treaty itself, and a case where a party seeks to take advantage of Article 11 for some ulterior purpose, such as to be a qualifying lender under a contract. in both cases, a main purpose of what you're doing is to take advantage of the treaty. There is certainly no need or justification, we respectfully submit, for substituting the language of the article with a gloss, which is the effect of the learned judge's approach, that there has to be an abuse, to use his words, or what you do has to be contrary to what he called the object and purpose of the treaty. This is, the second is certainly to pick up language from a learned friend's respondent's notice. And we pointed out at trial the approach taken in the BlackRock case. That was a domestic tax case. The key principles were identified by Lady Justice Falk. They're recorded at 270 of the judgment, apparently with approval from A to F, although there's no sign in the judgment that the learned judge went on actually to apply any of them. Now, the facts in BlackRock were complex. It's a real, if I may say respectfully, cold towel round the head case. But it boiled down on this point to this. What was the purpose of one particular company called LLC5 in entering into the transaction? And Lady Justice Falk answers that at paragraph 162 of the judgment. It's at page 630. And she notes that a simple starting point when ascertaining purpose is to ask why they did it. Now, well, I'm tempted to say that's obvious, and I mean no disrespect, but sometimes actually you can miss the wood for the trees. And what my respectful submission, Lady Justice Falk, is doing there is sort of grounding us and saying this is a very good way to ask and answer the question. And at 163, in that case, she explained the answer was indeed obvious, to use her word. Quotes, however it might be dressed up, LLC5 became a party to the loans to obtain a tax advantage. And Lord Justice Nugee, at page 635, says much the same thing, and indeed refers back to Lady Justice Falk's approach. I'm not going to read that out, given the time. And we respectfully submit this is precisely the question which the learned judge ought to have asked and answered in this case, and we submit it was inescapable. That we would say the purpose, certainly at least one of the main purposes, of using FWC incorporated in the UK as opposed to FWA or FWB or any FWs up to Z was to take advantage of Article 11. I mean, that's why they used this company, a UK company. There's no other reason ever been given. Now, let me now turn to my learned friend's submission that to fall foul of Article 11.7, the assignment of the loans has to be contrary to the object and purpose of the double tax treaty, so as to amount to an abuse of it. That's the third point in their respondent's notice, and as I said earlier, we disagree with it, but I'm not objecting to that third point in the way I objected to the first two. It's also in their written argument at 63 to 64. The short answer to this point is that that is not what the article says. The learned friend is trying to put a gloss, rewrite, I might say, the article. There's simply no need or warrant or basis to substitute the wording of the treaty with the additional wording. And if we see this as an anti-abuse provision, the contracting parties to the treaty, so to speak, defined what the abuse is. They defined what the abuse is by their words in Article 11.7. In other words, that is the abuse which they are seeking to exclude and to prevent. It's not that you can't abuse it and then later on we have to decide what amounts to an abuse. Insofar as 11.7 is an anti-abuse provision, it's circumscribed by what 11.7 does and doesn't do. And although my learned friends in their skeleton rely on what they refer to as the OECD commentary, although in the footnote, the OECD guidance, that doesn't provide a justification for that. Now, my learned friend, Mr Thompson, has taken the court through the key passages. We're not going to go over that again. I don't think, I'll be corrected if I'm wrong, but I don't think we looked at 21.4. No. And that's because we have tried to split this up. This is at Authorities 28 at 752. And I just wanted to show the court paragraph 21.4 at page 752. Again, I'm not going to read it out, but the point I'm making is that the wording is in substance identical to what's included at Article 11.7 of the Double Tax Treaty. Now, this is not said to be subject to FWA's general abuse gloss. The suggested model clause simply refers to the main purpose, or one of the main purpose, to take advantage of the article. It doesn't say anything about object and purpose or abuse or anything like that. And the model clause is materially identical to 11.7.
I'll just ask this. It is the same as 7, but 11.7, the focus of it appears to me to be inquiring whether the purpose or main purpose, or one of the main purposes, of the assignment of the debt was to take advantage of the treaty. Your argument is slightly shifted, doesn't it, to say that the main purpose of incorporating or using FWC, a UK incorporated company, within that transaction was to take advantage of the treaty. It's not the purpose of the assignment. The purpose of the assignment here was to ensure that the FWC had the rights under it and could enforce those rights.
Well, yes, but an assignment, I respectfully understand where Milo was coming from, but an assignment has to have an assignor and an assignee. And when you're saying the effect of the purpose of the assignment, in my respectful submission, that brings in who is assigning from who is taking the assignment. It's not just, so to speak, the fact of the assignment, i.e. we, Fitzwalter as a general entity, would like to have this debt. There's an assignment to who? The assignment has to have parties to it. So it's a contract, there's a giver and a taker. So in my respectful submission, that is necessarily included within the meaning of the assignment. Lastly, can I, if the court will give me the same lunch indulgence as yesterday, literally a couple of minutes if I may. Lastly, can I turn to the learned judge's last comment at 278 of the judgment, which is the adverse inferences point. And the court has seen that I asked the only witness who was put forward the various questions, and you've seen the exchanges. And our submission is, as I've said, that the only rational conclusion the judge could have drawn was that FWC was incorporated in the UK for the purpose of enabling Fitzwalter to take advantage of Article 11, and that goes back to my assignment and the answer I gave to my Lord Justice Zacaroli a moment ago. But if necessary, we do submit that this is a prime case. We say it's a paradigm case where the court should draw adverse inferences from the failure to call Mr Gray, Muscott or any witness actually responsible for the decision to assign the loan to FWC. There was no explanation from the learned judge as to why he considered no inference should be drawn, why he thought that Mr Gray or any other person not called wouldn't have given relevant evidence. And despite having quoted the considerations identified as relevant in the FOB case, and I apprehend this court is more than familiar with that case, I'm not going to go back to it, at 274 of the judgment, he doesn't with respect explain why those considerations didn't apply to this case. We set this out in our written argument at paragraph 66. There were other witnesses available to give highly relevant evidence. And if I can just remind myself of one point, please. Yeah. A relevant, when the court saw in my questioning of Mr Weinstock, Bruton Street, which is in the heart, as the court knows, of Mayfair, which the court can take judicial notice is a popular location for hedge funds or vulture funds. That wasn't a joke question. The point was Mr Weinstock had flown in from New York to give evidence. And yet, and my point was, there were people sitting, so to speak, round the corner, a short hackney carriage ride away, who weren't in court to give evidence. And that, in my respectful submission, is relevant to the FOB point. It's one thing to say, I brought somebody from Mayfair, I didn't bring somebody from New York, although even these days that wouldn't be such a great argument. But we had no explanation why we ended up with somebody who didn't know from New York, where the people who did know were round the corner in Mayfair. And that was our FOB point, which we rely on as, so to speak, our fallback submission here. I'm sorry. Oh yes, perhaps I can quickly answer my Lord Justice Popplewell's question on default interest. There is a default interest provision, clause 8.2, supplemental bundle 8 at page 246. But if interest was payable, then paragraph 277 of the judgment we submit is still wrong, but for a different reason. Because if interest was in fact payable, then the judge was wrong to say that Article 11 of the DTT wasn't engaged. So to speak, that's our sort of slight heads, another heads I win, tails you lose point. If that hasn't completely satisfied my Lord, then perhaps we can respectfully pick it up after the short adjournment, because I'm just conscious I'm now treading on the court's patience. But I've tried to do that pretty quickly.
Thank you very much indeed. Given that we lost quite a lot of time this morning, I'm wondering whether it would be convenient for everybody if we reconvened at 10 to 2. Seems everybody nods, so I'll see you at 10 to 2.